All right, so this week we're having a look at the assignment, and that's because the Sale of Goods Act and the Australian Consumer Law section traverses over 2 weeks. And so this week we are, we did the tutorial questions for Sale of Goods and the Australian Consumer Law last week, the questions that are for the 2 weeks. And the intention then was to use this second week as an opportunity to spend a bit of time on the assignment, to work through the assignment and just articulate some key issues, thoughts in terms of the assignment questions, obviously with a view to assisting you in the process of going through the assignment and preparing your assignment answers and making it just a little bit clearer what some of the thoughts that I might have. But I think the important thing is that there's no right or wrong answer. It's not like a mathematical question or a chemical equation. It's more about the quality of the structure, the articulation, and the research and the referencing that you bring to each of your questions. The explanation and the way you structure that explanation is more important, and the identification of the issues are more important than necessarily the specific answer that you might get. I think the first thing, though, that I wanted to talk about was that for each of the assignment questions, I'll just try and bring up hopefully you can see that now. For each of the assignment questions, you should try, I think, to structure your answer in a way that focuses on a number of key headings. What is the question or questions that I'm being asked? Now, the question isn't discuss or analyse. The question is, you might have to generate the question because you have to analyse what the question isn't this text here on the page. It's what am I being asked? Once you've identified the question, you then need to identify the legal issue or issues that might be applicable to that question. Now, there might be a whole range of issues. There might be a range of issues that aren't even relevant to commercial law, but obviously your focus is on the legal issues relevant to commercial law. Once you've identified the question and the issues that relate to that question or questions, the third heading is to tease out the key facts in the question that are relevant to those issues. You've been given only a small amount of facts. In real life, obviously, there might be hundreds of facts. You might sit down with a client who says, I had bacon and eggs for breakfast. Well, that's not a relevant fact. But the relevant fact might be, well, I purchased a house on the 28th of June, 2013. How did you purchase that house, etc., etc.? So in real life, it's harder to distill out the relevant facts. In your question, you'll still have some facts which are not as relevant as others. So the distillation of what are the really key important facts that you need to rely on to deal with the issues at hand. Once you've done that, so the question, the issues, the facts, the fourth step is to say, okay, what's the applicable law? Are there cases? Are there statutes? Are there principles that come from the cases that are applicable to the issue at hand? And you need to articulate those. You'll find that that really should be the guts of your question, the body of your question, if we call it that. Once you've identified the law, the next step is to apply that law to the facts. To say, okay, the law says this, the facts that are relevant to that law are these, and that application might take a little bit of time and a little bit of articulation. Because this happened, the principle is that, so fact and law, that's the application process. The linkage of the facts to the law. Then you come to a conclusion. The reality is that two different lawyers, two different law students, two different students of commercial law might come to completely different conclusions. That doesn't matter. That's the reality of the legal profession. That's why we have case law, because people are in conflict about the facts and the law that apply to those facts. And that's why it isn't like a chemical equation in the sense that there will be grey areas, and these questions have intentionally been drafted so that there are grey areas involved. So don't be concerned about whether your conclusion is right or wrong. It's more about just coming to a conclusion. Your conclusion is effectively the answer to your issues, or it's where you deal with the issue at hand. You then should answer your question. You generated a question for yourself. You need to answer that question. So I'll give you an example. I'll give you a very simple example from contract law. I walk into a shop. I buy a chocolate bar. How do I know when I become the owner, if at all, of that chocolate bar? That's the little question you've been given. What's the question? When do I take ownership of the chocolate bar? What's the issue? The issue is an issue of contract law. Whether contract law governs my purchase of the chocolate bar. What are the facts? Well, I walked into a shop. I paid using some plastic money, as in not a credit card, but actual cash. I received some change. I didn't say that I even wanted to buy the chocolate bar. I put it just down on the counter. After I'd handed over the cash to the person, I said, thank you, picked up the chocolate bar and walked out. What are the legal principles? Well, for the formation of an oral, simple contract like that, there is offer, acceptance, consideration, and intention. To apply those legal principles to the facts, was there an agreement? Yes, there was. It was an oral agreement implied by conduct. Was there consideration? Yes. The consideration the shop gave me was the chocolate bar. The consideration that I gave the shop was the money, and I received some change. Was there an intention to be legally bound? Yes, it was a normal corner store that had the normal trappings of a shop, and it was a public store where you could buy things. What's the conclusion then as to whether a contract was formed? The conclusion is there was a contract, and the contract was formed at the time when I put the chocolate bar on the counter, and it was concluded by the time I received the change. The answer, when did I become the owner of the chocolate bar? Well, it was when I received the change. Now, I may be wrong on some of the points raised in there, but you can see that's an example. Now, if I was writing that up in an assignment, obviously I'd need to reference all of the principles. So where I mentioned consideration or intention or agreement or an offer or an acceptance or et cetera, I'd be trying to refer to case law and anything else I could. And I'd be referencing those using either the Harvard system or the footnote referencing system or a combination of both. And I don't mind what you use, whether you use Harvard or footnote referencing or a combination of the two. What I'm really focusing upon is the quality of the referencing that you do use. If I had a preference, it would certainly be for the footnote referencing style, and that's in accordance with the Australian Guide to Legal Citation, which is a Melbourne University publication. And it just sets out how you do referencing into the internet, cases, statutes, books, journal articles, newspaper articles, etc. Word count. Well, don't be too concerned if your word count is 3,200 words or 2,700 words. I'm not concerned about broad, general word counts that are in the realm of 3,000 words. Obviously, I'd be concerned if your word count was 6,000 words. And in the same, I'd be concerned if your word count was 800 words. You don't want to be too far from the realm, shall we say. But it's not about being, no more than 3,100 and no less than 2,900 or anything as specific as that. And of course, the 3,000 words is for all of the questions on your assignment. All right, so relating to what I've just said though, when I've referred to question, issue, fact, law, application, conclusion as key headings, they are headings that I'm using every day in my own practicing life when I'm dealing with problems. But I never am writing down law as a heading in an advice or in a document that I'm doing. I'm writing down contractual principles or Australian consumer law or the Competition and Consumer Act or promissory estoppel or etc. or injunction, etc., etc. So I'm writing down headings that are specific to the legal issue at hand. Fixtures, chattels, torts, whatever it is. So use as many headings and subheadings as you can. Make sure you structure your assignments in a very structured way, and keep your concepts clear and efficient. But don't use those headings, facts, law, application, conclusion, answer. Use substitutes for those that articulate what you're really talking about in that paragraph. All right. Now for question 1, you would have seen that I actually put on Moodle in the news forum, posted in the news forum, some notes or some text as to that question. I was asked a specific question about it by one student, and then in response to that posted some stuff. I should say that news forum, when I put things in there, it then gives me an option of mailing all of the subscribers to the news forum. And so when I click that and mail it, if you're a subscriber, you should be receiving an email that confirms that you're subscribing. Now, what you might need to do is check your subscription settings or your own personal settings on Moodle. Because, for example, I get the subscription myself, but I get it later in the day. I've set it up so I get it later in the day. Anyway, so let's go through. So I won't make significant comments about question 1, but let's go through it anyway. In any event, Mary and Anthony have recently purchased a large Queenslander-style home in Paddington. The property was attractive to them because they are budding chefs and wish to open their own restaurant. They feel that Paddington is a suitable suburb for them because of the young demographic and vibrant restaurant scene. Prior to the purchase, Mary and Anthony were particularly happy that the brochure given to them by Harry the agent from Dime a Dozen Real Estate Pty Ltd stated that the house had planning permission for a restaurant to be operated from the premises. After the transaction settled, Mary and Anthony became aware there was no planning permission for a restaurant. A planning application had been submitted, but had not, as yet, been approved. Further, when Mary and Anthony inspected the property prior to purchase, there was a large brick pizza oven in the backyard which was capable of cooking commercial quantities of pizza. They were excited by the prospect of this pizza oven because it fitted in with their plans to start a restaurant. 2 days after settlement, Mary visited the property and realised the pizza oven had been removed by Sam, the vendor. There was no provision in the contract of sale for Sam to remove the pizza oven. Discuss the material facts above by reference to legislation and case law. So you've got two key issues. The first key issue is about this idea that there's been a representation of some sort made regarding the planning permission for a restaurant. So you could deal with that in a number of ways. It's potentially a contractual misrepresentation, so a misrepresentation in contract. It's potentially a tortious misrepresentation, so a negligent misrepresentation in tort. And it's potentially a breach of the Competition and Consumer Act, the Australian consumer law, in that it's a representation made by an agent who works for a company, Diamond Dozen Real Estate Pty Ltd. You'll see that the notes that I've put on the Moodle for this first issue, the first part of the question, relate predominantly to that concept of the company representing something and therefore creating a statutory breach of the Act. Now, why do you've got different choices. You can sue in contract law, tort law, statutory law. Why would you pick the statutory law? Because it gives you the most remedies, gives you the greatest options in terms of remedies. You can get money, you can get the contract, you can get something changed, you can get corrective advertising, you can get a fine, you can get an injunction, you can get specific performance. In torts, you only have maybe damages, maybe rescission of the contract, maybe. And in contract law, you might only have damages or something like that. So you've got limited rights depending on which cause of action you use. It sounds like, without forming a concluded view, it sounds like there's a fairly clear misrepresentation here, something which was obviously important to the purchasers and something which is not now available to them. That would at least surely provide some basis for damages, and you'd need to articulate the basis. And you'll see on the Moodle I've put something quite clear in that. Now, the second part of the question is really a property question, because it's focusing upon this issue of what's a fixture and what's a chattel. So it's not a contractual question because the contract of sale didn't include a specific reference one way or the other to the pizza oven. So we need to ask some questions. We really don't know some of the things that might be quite critical to this pizza oven. Firstly, was it anchored, secured to the ground or to a structure in some way? And there's even some issues there. If it was just connected to the ground for usage, so maybe there's a case, for example, about a printing press or printing presses, and they were just connected to the ground just so that the press didn't move around on the floor because it was this big, heavy printing press. If it was just connected for usage as opposed to being connected for permanent or for some level of permanency, that might change the position. We're told it's a commercial oven. I mean, it's going to be potential. We're not told how it's fired, whether it's fired by gas or natural log or wood or coal or something, or whether it's electric. And we're not told any of those things, but we might need to make some sort of presumption about that. The other thing I think which is key is we're not told whether it's built in. What I'm talking about there is, has there been is there a brick surround, and then when you take the pizza oven out, the brick surround is left with nothing in it. So what's the structure that surrounds it? And in fact, those key questions, and you'll see what it says. It says, discuss the material facts above. In fact, it's those key questions that will give you the ability to answer the question. Without those key questions, it'll be very difficult for you to answer the question in the second part. But there's nothing that actually indicates that it is a fixture. And without some significant trigger, such as it was concreted into the ground, it was surrounded by bricks, things that would trigger it becoming a fixture, I think on the information that you currently have, it's not mentioned in the contract, there's no indication that it is a fixture. You can, I think, take it as being that it was a chattel and it could have been taken in the contractual process. 2A. Next door to Mary and Anthony's Paddington, Queenslander home is a building site. Their neighbours inherited the property following the death of a close relative and have begun renovations. As nobody has lived in the property for a long time, there are a number of overhanging branches that cross the property boundary. Mary has taken it upon herself to cut the branches down, but she is not sure if she should undertake such an action. The neighbours also have a bad habit of buying firewood and lighting large bonfires at night, which results in Mary and Anthony's property being covered in a thin film of black soot, discussed by reference to case law. So you've got two real issues here. You've been specifically told to discuss by reference to case law because, in fact, in Queensland now, there's I think it's called the Neighbourhood Disputes Dividing Fence and Tree Act 2011 or something like that. And that would govern at least the first of the two issues in question 2A. That's the issue about the overhanging branches. And it statutorily imposes itself on that circumstance. But for your purposes, you don't need to look at that act. You don't even need to mention that act. Your focus is on the tortious interface between the two properties. So there we're talking about trespass and nuisance. And really the overhanging branches is a question of trespass and nuisance. The thin film of black soot is potentially also a question of trespass and nuisance, but it's probably more a question of nuisance. And there's some great case law that you can look at if you look at those two issues, trespass and nuisance. I remember all those cases about someone, for example, firing a gun across the air above a person's property and whether that constituted trespass or nuisance. Another one was moving. Another one was noxious fumes from a school in Brisbane, which were transferring from the school across the boundary line. And it just happened to be that there was a science classroom there and they do science experiments every day, coming across into the neighbouring property. A bit like the thin film of black soot and whether that constituted nuisance. Another one was a large construction crane at night swinging out over the property, over the top of the property, and whether that constituted nuisance. So there'll be some cases that you might be able to identify that can assist you in determining whether the overhanging branches constitute trespass or nuisance and whether the thin film of black soot would constitute trespass and nuisance, and what might trigger those causes of action in those circumstances. It's only 5 marks, remember. So out of 3,000 words, if the first remembering that you've got 4 questions of 10, 5, 5, 10, 5, 5. So 3,000 divided by 3,000 divided by 4 is 750, divided by 2 is 375 for question 2A. So just 375 words. So where you've got 2 issues, you'd only spend 187 words on the issue of the overhanging branches and 187 words on the issue of the thin film of black soot. 2B, Mary is a keen musician and has composed many pieces of music. Last year, she was employed by the Brisbane City Council to create a jingle for the council that embodied the spirit and character of the city. Mary has since found out that a documentary about the town, created by the council, features the jingle she composed. There is no written contract between Mary and the council with respect to the jingle. Mary believes her copyright has been infringed by including the jingle in the documentary without her permission, and that she should receive royalties from the council. So obviously here you're focusing on 2 things. One, a statutory breach of the Copyright Act, and you don't need to examine hundreds and hundreds of sections. It's just a very, very broad brush assessment of whether a copyright has occurred. Once again, you'd only spend about 180 words on that, but by reference to the statutes and the case law, and obviously you'd need to confirm whether music is a copyright or is a copyright material, and really what we want to find out is confirm that whether this jingle is in fact close enough, proximate enough to the jingle that she did compose, such as to breach a copyright that she may have had. There's no indication that she was obviously employed, but there was no contract. So was she paid at all? So there might be some questions for you to ask there. But the second part of the question is whether there was passing off. A tort has occurred, and that tortious action can be acted upon, or can be a cause of action separate from the Copyright Act. So have they tried to pass off her work or her work as something that the council have done? I mean, I think it's harder for them to prove a passing off in the sense that they employed her. The question is really whether that employment whether there was sufficient consideration to create a binding contractual relationship. If there was, then there probably isn't a copyright breach at all. They've hired her, and she has probably waived that copyright in that they've hired her to make the music for them. So, in fact, the likelihood is that there's no copyright at all. But obviously you're going to have to come to some view about whether there's a sufficient contractual basis, even if they haven't talked about waiving her rights or waiving their rights in terms of the intellectual property. If I ask someone to draw a drawing for me and I pay them to do that, surely I become the owner of that drawing when they've drawn it for me. Let's say they draw a picture of someone I know and I pay them to draw that picture. Surely when I paid them, I then take over that intellectual property over that picture. Maybe I don't. So there's some questions there. But maybe they retain the intellectual property, but they're in fact licensing it to me for money or something like that. So you've got to think very carefully about how this is really being set up. What's the setup here? So it's not such a clear copyright question, as it's in a lot of ways it's a bit of a copyright having regard to contracts question, or tort having regard to contracts. And I think that's really the issue. Question 3. Anthony is fanatical about airplanes and owns a small Cessna, which he flies for hobby purposes. Anthony's friend David services planes at his business called Don't Fall Out of the Sky Pty Ltd. It's sad because when you read this question, you think about that Cessna that went down, was it last week or the week before? Unfortunately, David's apprentice forgets to lock up the workshop on the night that Anthony drops off his plane for servicing. Anthony's plane is subsequently stolen by thieves who were watching the workshop. The apprentice also failed to remove the keys from Anthony's plane. David forgot to get Anthony to sign a service contract and tells Anthony he cannot accept any blame as the theft is the fault of the apprentice. So there's really two issues here. One is vicarious liability. That is, to what extent is the business, Don't Fall Out of the Sky Pty Ltd, liable for the actions of its employee? And two, to what extent is anyone, the business or the apprentice, liable for when there are actions that, when the responsibility between them is broken by criminality, by a criminal action which breaks the relationship, the chain of causation between Anthony and the business. And when I remember I did a case in Toowoomba many, many years ago now, probably more than 10 years ago, and it involved the contents of a property. And when I say the contents of the property, everything. Silverware, jewellery, furniture, clothing, family heirlooms, the lot. And it was in one of those storage facilities. And thieves had broken into this storage facility and taken all of the good stuff from this storage facility of one particular family, of the particular family involved. And I was acting on behalf of the insurance company who had, when they paid the family for all the losses, had then sought to sue, they didn't know who the thieves were at that time, but sought to sue the storage company for the lack of, for their actions in securing this facility. And my recollection is that we did not win the case, and the reason we did not win the case was that there had been a criminal break in the chain of causation, that the thieves, that the causation couldn't be proven clearly because the thieves had broken that chain. The responsibility was effectively lost. And I think that's the key principle here for you, that it's very difficult to blame either the apprentice or the company where an intervening third party comes in and breaks the chain of causation. There's a High Court case in about 2000, from recollection, and it's called Modbury, Modbury Park, and Anzil, I think it is, Anzil. And that case was about a shopping centre car park in Adelaide, from recollection. And what happened was that one of the workers in the shopping centre went back out to his or her car. I can't remember some of the details of the case, but they went back out to their car at night. And when they were doing that, as they were going back out to the car, the shopping centre had an automatic timer on the lights, and they switched off all the lights. And of course, as the person got to their car, they were robbed they were in a, they were, their stuff was taken from them, but they were also assaulted physically. So they suffered both physical harm and had some financial stuff taken off them. And the question was, of course, was the shopping centre in some way liable for the fact that they had turned off the lights and had, by this automatic timing system, and had therefore done something wrong? And the High Court said no, because there was an intervening criminal act on the part of these criminals. All right, 4A. The plumbing at the new Paddington House requires significant improvement. Anthony contacts a mate of a mate called Robin, who runs a plumbing company called Toilet Fix Pty Ltd. Robin's contract of service states Toilet Fix Pty Ltd will only accept liability for plumbing defects arising within a 6-week period following the contractual completion date, discussed by reference to legislation and case law. So here we have an exclusion clause, an exemption clause, a no liability clause, however it's so described. Now these clauses, there are 3 specific rules about these clauses which are really quite important. The first is called the contra, C-O-N-T-R-A, proferentum, P-R-O-F-E-R-E-N-T-U-M, contra proferentum rule. And what that means is that if there's any uncertainty in the wording, and so for example here, what does plumbing defects mean? If there's any uncertainty in the wording in this clause, in the contract, the uncertainty will always favour the consumer over the company. So for example, I go into a car park, the car park says, we accept no liability for damage caused to motor vehicles. The car park allows me to park my bicycle in the car park, and I pay them a fee of $5 for parking my bicycle there. My bicycle is smashed by a car park attendant reversing a car into the bicycle. And I want to take action against the car park attendant and the car park. And they say, well, no, we don't have any liability for motor vehicles parked in the car park. And let's say it went to court and a judge was being asked to interpret the meaning of what a motor vehicle is. Where there is uncertainty, that clause will be read in favour of the consumer. And motor vehicle might be said to mean a car as opposed to a bicycle. That's the first rule. Second rule, the term in question, Toilet Fix Pty Ltd will only accept liability, that term must be part of the contractual agreement before the agreement is made. So after you've made the agreement, you can't be sent through the post a copy of some new term and they say, well, now we've told you this is a term of the contract. No, it must be part of the agreement before the agreement is made. Thirdly, you must have reasonable notice of the term. So if the term is if you're given a written contract document and on the back it says, see our website for terms and conditions, and you never go to the website and you never see that there's these terms and conditions which include Toilet Fix Pty Ltd will only accept liability, well, that's not reasonable notice. Another example that might not be reasonable notice is if you do the contract online and it says, tick box here to confirm that you agree with all of the terms and conditions. And when you start scrolling down on the page, there are 312 pages of text which are all terms and conditions relevant to the contract. And on the 311th page, it says Toilet Fix Pty Ltd will only accept liability. And before you even could read 312 pages, the web page would time out. So, in fact, that would not be reasonable notice, potentially, of this term and condition, potentially. So they are things that might be relevant as to that question. And you might be able to avoid this exclusion clause by virtue of the Australian consumer law, but you cannot normally avoid it by virtue of legislation such as the Sale of Goods Act. And of course, this isn't a sale of a good. So you'd need to be looking at the Australian consumer law to see whether it will, in these circumstances, override the written contractual relationship between the parties. Mary is a keen golfer, but her golf handicap is not very low, and she often comes last in her weekly competitions at the golf club. She sees an advertisement from Leisure Sports Pty Ltd in a golf magazine for a special arm sling that promises to substantially improve her game within 21 days. 4 weeks after purchasing the product, Mary is still coming last in her weekly golf competition, and the golf game has actually gotten worse. Anthony recommends that Mary communicate to the Australian Competition and Consumer Commission. Well, so this is a classic Carlisle and Carbolic Smokeball company. A unilateral offer made to the world. You accept that offer, you purchase the good, or you pay good consideration. The question is whether there's then a breach of the contractual relationship. But there's also potentially an Australian consumer law breach as well. Is it misleading and deceptive conduct under Section 18 of the Australian Consumer Law, which is the schedule to the to the Competition and Consumer Act, and of course the ACCC are the protectors, that the government body that looks after that act, that protects that act. All right, so they're just some initial points about your assignment. Of course, they're not answers, and you might choose to deal with the questions in a different way. It is about the quality of the text that you put together, the quality of the referencing and the structure that you use. Make sure you articulate straight away for yourself how many words approximately you need to do on each question or subpart of each question, and that'll help you to realise that it's not a huge mountain to climb in terms of completing what you've got to do. Next week I'll do some preparation for your examination initially, and then we'll do some further exam preparation obviously as the semester goes on.